Tonight, those affected by President Trump's federal funding freeze have a little longer to clear up confusion over the order. A federal judge has temporarily halted it. Earlier today, top Senate Democrat Chuck Schumer sharply criticized the action.
This decision is lawless, it's destructive, it's dangerous, it's cruel, it's illegal, and it's unconstitutional. Donald Trump has done a lot of bad things in the last week.
Imagine a world where the prosecutor becomes the defendant. On October 9th, 2025, the American legal system shifted on its axis as a federal grand jury indicted New York Attorney General Letitia James. This isn't just another legal headline. It is the most serious collision between executive power and state law in our history. Today, we pull back the curtain on the Retribution campaign and the $454 million battle that started it all. Start the clip here. Good evening. There are moments in the history of a democracy where the mechanics of the law stop being background noise and start becoming the main event.
The Trump administration announced a sweeping freeze on all federal grants, funds already approved by Congress. Chief Washington correspondent John Carl is tracking Trump's executive action. John, the administration says this is just a temporary pause, but it could have major consequences.
George, look, there is a lot of confusion this morning about what exactly this directive means, but it may be the most far-reaching.
We are living through one of those moments right now. It is a moment defined by a single word that has haunted the halls of the Justice Department and the courtrooms of New York for years: accountability. But the question tonight is, who is being held accountable and by whom? On Thursday, October 9th, 2025,
executive action this White House has taken yet. It could potentially halt hundreds of billions of dollars in federal spending on everything from assistance to farmers to Head Start programs to disaster relief and public transportation.
A grand jury in the Eastern District of Virginia did something that was once unthinkable. They indicted the sitting Attorney General of the state of New York, Letitia James. The charge is one count of bank fraud and making false statements to a financial institution. Specifically, the investigation centers on a mortgage fraud inquiry related to a home purchase. Letitia James has denied any wrongdoing. She says it was a clerical error that she corrected immediately. But the context here is everything. This is the latest and perhaps most aggressive move by the Trump administration to use the Department of Justice to pursue those the president considers his political foes. Letitia James is not just any political foe. She is the woman who won a staggering multi-hundred-million-dollar judgment against Donald Trump and his companies. That judgment found that for years, the Trump organization engaged in persistent fraud by lying to banks and insurance companies about the true value of its assets. James herself has decried this new indictment as nothing more than a continuation of what she calls the president's desperate weaponization of our justice system. She says the goal is political retribution at any cost. To understand how we reach this point of total legal warfare, we have to go back. We have to look at the foundations of the civil fraud case that set this entire chain of events in motion. It started in a New York courtroom presided over by Justice Arthur Engoron. After an 11-week trial, Justice Engoron issued a 92-page decision that was, by any measure, devastating. The court found that Donald Trump and his entities owned valuable properties, office buildings, hotels, and golf courses. Developing these properties required massive amounts of cash. To get that cash, they borrowed from banks. Those banks required personal guarantees from Donald Trump. Those guarantees were based on statements of financial condition. Here is the core of the findings. To borrow more money at lower interest rates, the defendants submitted blatantly false financial data. This resulted in fraudulent financial statements. The court didn't just say these were mistakes. It said the defendants simply denied reality when confronted with the evidence. They failed to accept responsibility. They failed to impose internal controls. Because of this, the court found them liable for repeated and persistent fraud. The numbers involved are not minor. The final judgment ordered Donald Trump and his companies to pay close to $454 million, including interest. For most people, that is an astronomical sum. For a billionaire who has built his entire brand on the image of success and wealth, it was a direct threat to his business empire. Under New York law, specifically the Civil Practice Law and Rules, or CPLR, a judgment is not just a piece of paper, it is a mandate. But a judgment is only as good as the state's ability to enforce it. This brings us to a very technical and very serious part of our legal system, judgment enforcement. Ordinarily, if you win a case and the other side refuses to pay, you have two main options: execution or contempt. Execution is the process where a sheriff or local law enforcement actually seizes and liquidates property to pay the debt. Contempt is a tool used to force a party to comply with a court order through fines or even imprisonment. Letitia James signaled early on that she was prepared to seize Donald Trump's assets if he missed his payment deadlines. We are talking about prized real estate holdings like 40 Wall Street in Manhattan and his penthouse in Trump Tower. The former president's legal team argued that the $454 million bond required to pause the collection during his appeal was a practical impossibility. They said the amount was too steep and he couldn't raise the funds in time. In a significant turn of events, a mid-level state appeals court granted a pause on the full collection. They gave him 10 days to post a smaller $175 million bond. This ruling was a major victory for Donald Trump, as it temporarily blocked New York authorities from beginning the seizure of his assets. But even with this reduction, the pressure was immense. The interest on the original judgment was accruing at over $114,000 per day. The tide was going out, and the financial world was watching to see how much liquid cash the self-proclaimed billionaire actually had. The court findings showed that many of the values he claimed were based on what Michael Cohen called reverse engineering. Cohen testified that he was tasked with increasing total assets based on a number Donald Trump arbitrarily selected. They would find the highest price per square foot achieved anywhere in New York and apply it to Trump's assets, even if the properties weren't comparable. They were starting with a desired net worth and working backward to find the numbers to justify it. One of the most famous examples from the trial involved Donald Trump's own home, the triplex apartment in Trump Tower. For years, the Trump organization valued that apartment as if it were 30,000 square feet. But property records, which Donald Trump himself had signed, showed it was actually only 10,196 square feet. That is a threefold exaggeration. This single misrepresentation resulted in an overvaluation of between $114 million and $207 million every year. The court found that even when Forbes magazine brought the actual size to the attention of Trump's team, they decided to leave it alone and continue using the false 30,000 square foot number in their certifications to accountants. It wasn't corrected until after the information became public in a Forbes article in 2017. Then there is Mar-a-Lago. Donald Trump insisted that the property was worth between $1 billion and $1.5 billion. But to reach that number, you have to value it as a private residence that could be sold to an individual. The problem? In 1995 and 2002, Donald Trump signed deeds giving up the right to use or develop Mar-a-Lago for any purpose other than as a social club. He did this in exchange for significantly lower property taxes. The court found there was no legal gray area here. The deed restrictions are permanent. Valuing Mar-a-Lago as a private residence when the law says it can only be a social club was found to be fraudulent. These are documented facts from the trial, and they form the basis of the staggering fraud that Attorney General Letitia James successfully prosecuted. This brings us back to the present day and the indictment of Letitia James. The Trump administration is now pursuing her with the same zeal she used to pursue the Trump Organization. President Trump has pushed his administration to ramp up what he calls a retribution campaign against his foes. James says these charges are baseless and a grave violation of our constitutional order. But there is another layer to this story that has been circulating online. You may have seen reports or videos claiming that a federal judge issued an emergency order freezing all of Donald Trump's assets nationwide on New Year's Eve of 2025. These reports claimed that properties like Mar-a-Lago and Trump Tower were being locked down in a complete financial paralysis. We need to be very clear about what is fact and what is fiction here. There is no verified report of a Manhattan federal judge freezing all of Trump's assets nationwide on December 31st, 2025. This specific narrative appears to be a combination of real legal pressures mixed with fabricated details to create a fake Trump collapse story. The real legal pressure is substantial enough without needing to invent more. Donald Trump does face significant financial strain from the Eugene Carroll defamation judgment and the New York civil fraud penalty. He has had to post large bonds. There is an independent monitor, Judge Barbara Jones, overseeing the Trump Organization's finances. In her final reports, Judge Jones found that the internal accounting structure of the company continued to be plagued by math and/or reporting errors. She found that the company was omitting significant liabilities from its disclosures. She even noted that the Trump organization transferred $40 million without notifying her, as they were required to do. This reality is complex and evolving. It doesn't happen in a sudden, dramatic freeze on a single holiday. It happens through a slow, methodical process of court filings, monitor reports, and appeals. The claim that assets were being seized piece by piece on New Year's Eve is simply not documented by any credible news organization like the AP or Reuters. So why does this misinformation spread? Because there is a high demand for it. People who oppose the president want to see immediate consequences, and content creators supply that demand with viral but unverified stories. But these fake stories can be corrosive. They make everyone more confused about what is actually true, and they allow supporters to argue that all legal challenges against the president are just coordinated media attacks. To navigate this, we have to understand how the law actually works. Asset freezes are extraordinary remedies. They require a judge to find specific evidence that someone is trying to hide assets or is a flight risk. If an order like that were issued against a sitting or former president, it would be a public document available in the court docket for everyone to see. The absence of those documents tells us the story is manufactured. What is not manufactured is the doctrine of presidential immunity, which is currently a central focus of the Supreme Court. Special counsel Jack Smith's prosecution of Donald Trump for allegedly attempting to overturn the 2020 election has brought these questions to the forefront. The former president argues that he is shielded from criminal prosecution for official acts taken while in office. He even argues that since he was acquitted by the Senate in his impeachment trial, he cannot be prosecuted for the same conduct due to the impeachment judgment clause. This is a profound constitutional question. The Supreme Court has previously held in Nixon versus Fitzgerald that a president has absolute immunity from civil suits for official acts. They reasoned that without this protection, a president might be unduly cautious in discharging their duties. But in Clinton versus Jones, the court clarified that this immunity does not apply to unofficial or private acts. The current battle is over whether that immunity extends to criminal acts. A unanimous panel of the D.C. Circuit Court of Appeals recently rejected Trump's claim of categorical immunity. They ruled that when a former president allegedly violates federal criminal law, those acts cannot be viewed as within the scope of lawful discretion. They found that the public interest in criminal accountability outweighs the risk of chilling presidential action. The Supreme Court is now set to provide the final word on this issue. While these grand constitutional battles play out in Washington, the street-level legal enforcement continues in New York. We have to look at the mechanics of how the state of New York actually collects on a money judgment. This isn't just about sending a bill. The CPLR gives the judgment creditor, in this case the people of New York represented by the Attorney General, powerful tools. They can issue a restraining notice. This serves as an injunction prohibiting anyone from transferring the judgment debtor's property. It can be served on the debtor or on a third party, like a bank. Once that notice is served, that property is effectively frozen in place. This is the kernel of truth that the fake nationwide freeze stories are built on. If the debtor still doesn't pay, the creditor moves to execution and levy. This is where the sheriff comes in. The sheriff is required to exercise reasonable diligence to locate and seize property. If the property is capable of delivery, like a car or cash, the sheriff takes it into custody. If it's not, like a debt owed to the debtor, the sheriff serves the execution on the person who owes the money. This process is technical and, as some legal experts say, almost arcane, but it is the primary way our system ensures that court orders are more than just a piece of paper with a raised seal. The system is designed to be coercive. It uses the threat of fines and even imprisonment for contempt to compel payment. If a court finds that a debtor's violation of an order was willful, the consequences become very real, very fast. In the Trump case, the court has already found that the defendants used patently false data to get what they wanted. Justice Engoron noted that the frauds leap off the page and shock the conscience. He famously said that while he couldn't define a firm percentage for what makes a misstatement material, any number that is at least 10% off is significant, and anything 50% off is likely material. When we are talking about exaggerations of hundreds of millions of dollars, the law doesn't consider those trifles. The human cost of this legal battle is also significant. The Trump Organization is not just a collection of buildings. It is an employer of thousands of people. These are workers at golf courses, hotels, and resorts who depend on their jobs for their livelihoods. If assets are liquidated or if the company collapses under the weight of these judgments, these people who committed no fraud and did nothing wrong suffer the consequences. Then there is the impact on our political discourse. The Trump brand is built on success, winning, and wealth. When federal and state courts repeatedly find evidence of fraud and order asset freezes or massive penalties, it cuts at the heart of that image. It creates a contradiction between political power and financial powerlessness that is stark and jarring. As we watch the indictment of Letitia James move forward, we are seeing the ultimate expression of that contradiction. Is this a legitimate prosecution of bank fraud, or is it, as James claims, a baseless act of retribution? The American public is being asked to choose between two very different versions of reality. In one version, the legal system is finally catching up with a con man who has lived off other people's money for decades. In this view, the massive judgments and monitorships are the necessary tools of justice to protect the integrity of the marketplace. New York is the financial capital of the world, and the court argued that the state has a quasi-sovereign interest in ensuring that businesses within its borders adhere to standards of fairness. In the other version, a successful businessman is being persecuted by biased judges and politically motivated prosecutors who want to derail his career. In this view, the indictment of Letitia James is a long overdue counterstrike against someone who weaponized the law for political gain. What the documented facts tell us is that the New York civil fraud case was not a garden variety matter. It was a massive investigation that began in 2020 and involved the enforcement of series of subpoenas. It resulted in findings that were corroborated by dozens of witnesses and thousands of pages of documents. We saw testimony from accountants like Donald Bender, who worked for the Trump Organization for decades. He testified that the company withheld records, like appraisals, that his firm had requested while preparing the financial statements. Because of this, the firm eventually terminated its relationship with the Trump Organization. We saw testimony from bank risk officers like Nicholas Haig at Deutsche Bank. He made it clear that the bank would not have made these loans without a strong personal guarantee from Donald Trump. He relied on the financial statements and assumed they were broadly accurate. The bank even applied a standard 50% haircut to the property values Trump provided, just to be conservative in case of a market downturn. But even with that haircut, they were operating on numbers that the court later found were fundamentally false. We saw testimony from appraisers like Doug Larson, who discovered his name was being used to justify capitalization rates he never recommended. He called the use of his name inappropriate and inaccurate. And we saw the testimony of Donald Trump himself. He frequently interjected long speeches on issues far beyond the scope of the trial. He interjected that Mar-a-Lago was very underestimated and that his financial statements actually undervalued his assets. He claimed that even though he signed deeds restricting Mar-a-Lago to a social club, intend doesn't mean we will do it. The court found his refusal to answer questions directly severely compromised his credibility. These are not opinions. They are the findings of fact from a non-jury trial where the judge sat a yard away from the witnesses and observed their body language and demeanor for 11 weeks. The court concluded that the defendant's complete lack of contrition and remorse borders on pathological. The judgment issued by Justice Engoron didn't just order a payment. It also permanently enjoined the former CFO, Alan Weisselberg, and the former controller, Jeffrey McConney, from ever serving in a financial control function for any New York business. It barred Donald Trump from serving as an officer or director of any New York company for 3 years. It barred his sons, Eric and Donald Jr., for 2 years. This is the level of corporate malfeasance that leads a court to appoint a two-tiered oversight system, an independent monitor and an independent director of compliance. The court noted that this was not defendant's first rodeo, pointing to the $25 million settlement over Trump University and the dissolution of the Trump Foundation for persistent violations of law. Now, as the federal indictment of Letitia James proceeds, the question is whether the rule of law is a neutral principle or a weapon of the powerful. The Attorney General says the president's actions are a grave violation. The president says he has done nothing wrong. The legal mechanisms of the state are now being turned against the very people who use them to secure a $500 million judgment. In the process, the very definition of a fair trial is being tested. If a grand jury can indict an attorney general for a mortgage error while she is in the middle of an enforcement action against the president. What does that mean for the independence of the Justice Department? And what does it mean for the ordinary citizens involved? The people who work in the New York court system, the clerks, the staff, and the employees of the Trump organization who are caught in this crossfire. The human cost of this battle often gets lost in the headlines about billionaires and indictments, but it is a dimension that defines the real-world impact of these legal maneuvers. As we follow this story, we have to look for the documentation. We have to check the court dockets and demand credible reporting. We have to distinguish between the viral narratives of nationwide collapses and the actual methodical enforcement of money judgments. One thing is certain, this is history unfolding in real time. The implications for the presidency, for the state of New York, and for the American judicial system will be felt for years to come. The battle over the $454 million judgment was never just about money. It was about whether a single individual can be too powerful to be held accountable, or whether the law is indeed a raised seal and a signature that everyone must respect. The indictment of Letitia James on October 9th, 2025 is a new chapter in this saga. It is a development that raises the stakes to their highest point yet. It is no longer just a civil fraud case in a state court. It is a full-scale constitutional crisis involving the federal government's power to target state officials. As we continue to track these developments, we will look to the facts. We will look to the trial transcripts, the court orders, and the credible news reports that cut through the noise. Because in a democracy, the truth shouldn't be a matter of which side you're on. It should be a matter of what we can verify. There are plenty of genuine news items worth understanding without the manufactured crisis narratives. The real story of Trump's finances is complex, evolving, and playing out through normal, if incredibly high stakes, legal processes. It is a story of likely fraud, ill-gotten gains, and a staggering loss of credibility in the eyes of the court. But it is also a story of a president who is determined to use every tool at his disposal to fight back. Whether you call it accountability or retribution depends on where you stand. But the facts of the case, the square footage of the triplex, the deed restrictions on Mar-a-Lago, and the daily interest on a multi-$100 million judgment, those are the anchor points in a storm of political drama. The next few weeks will likely see even more dramatic developments. As the 10-day windows for bonds close, and as the discovery in the Letitia James indictment begins, the liquidation clock is ticking. We will be here to connect the dots, to separate the recycled news from the breaking developments, and to provide the context you need to understand what is actually happening to the American legal system. For now, the battle continues. On one side, the Attorney General who won the biggest civil fraud case in New York history. On the other side, the president who is now using the federal government to put her in the defendant's chair. It is a complete lockdown of the legal world, and the implications are truly staggering. As we move toward the 2026 midterms and the end of the president's term, these contradictions will define how history remembers this era. They will shape the future of American capitalism, the power of the presidency, and the very meaning of equality under the law. Thank you for joining us tonight. We will keep checking the dockets, we will keep searching for the court orders, and we will keep bringing you the stories that matter with the verification you deserve. The truth is out there, documented in thousands of pages of trial testimony and legal filings. We just have to be willing to look. Stay tuned for more updates on this rapidly developing story. History is happening right now, and we are all witnesses to it. Good night. To understand the New York civil fraud judgment, think of it as a professional athlete who gets caught using performance-enhancing drugs to win a championship. They might have the trophy and the endorsements, but once the test results come back, the league takes away the title and issues a massive fine to protect the integrity of the sport. In this case, the court found the test results showed a pattern of financial deception used to secure trophies in the form of low-interest loans. And the $454 million penalty is the league's way of saying that the rules of the financial marketplace apply to everyone, no matter how famous the player.